Well, a very interesting decision by the Supreme Court. But what do you make of the decision, especially on the matter of interpretation?
Well, did they interpret the Article 97(1)(g)? I don't think they interpreted it. What they did was to express their opinion on what Article 97(1)(g) means. They didn't interpret it.
Express their opinion.
Yes, and
what's the difference?
Well, in interpreting the Constitution, you have to look at all the Constitution as a whole, the document as a whole, and then look at the historical antecedents. Look at what would have informed the inclusion of Article 97(1)(g) and (h) in the Constitution. What, in the view of the drafters, was Article 97(1)(g) and (h) intended to cure? But when you read the judgment, you don't see it. In fact, as Justice Dakoa Sare's judgment was full of high-sounding words, but was not logical at all. He just took words in the Article 97(1)(g) and (h) and put his own understanding on it. He did not even have the presence of mind to look at Article 97 as a self-contained article that talks about how a vacancy occurs in Parliament, to do a dispassionate analysis of the ramifications of 97, especially 97(1), A, B, C, D, E, H, E, F, G, H, in that order, categorize them and show us their remit, and show why 97(1)(g) and (h) is not prospective but contemporaneous. So he did not do that. He just said that 97(1)(g) and (h) are contemporaneous, and the contemporaneity of the action rests with.
Well, we'll get ALHAJI back on the line. We've lost ALHAJI INUSAH FUSEINI. He says what he hears is persons expressing their opinion on what the Constitution says. But essentially, he doesn't hear an interpretation of the Constitution. And that's why, Nancy, when you asked me that word.
Mr. say, when
does the person
yes.
leave? Even the people who know. So I'll ask ALHAJI that question based on the decision. I'll ask that question. ALHAJI, thank you very much for joining us again. You were talking about the ruling as far as lawyer Asari is concerned. Justice is concerned. Justice Asari is concerned. You're saying that when you don't see an interpretation, you see an expression of opinion.
An expression of opinion in what he thinks 97(1)(g) means. Interpretation is more than an opinion. It's a complete dispassionate analysis of the provision in 97(1)(g) and (h) as against other sections of the Constitution, as against the 1979 Constitution, 1969 Constitution, 1960 Constitution, if there were similar provisions, what the drafters intended Article 97(1)(g) and (h) to cure, what the various sections of Article 97 is about, and how it relates, because you must be looking at the internal consistency of the provision, because every provision of law must be internally consistent with other provisions of the law. So in doing an interpretation, you don't just express an opinion on what you think 97(1)(g) means. You have to do an examination of that provision against other provisions.
And when we read both opinions, concurring opinions that represented the majority of judges, you're saying that you don't see an interpretation.
So Asari Danko or Danko Asari's judgment was the lead judgment. Then there was a concurring judgment from Asiedu. Asiedu took a different route, but came to the same conclusion. Asiedu attempted what I'm talking about. They attempted to deal with 97 as a whole, and then the relationship between 97, what 97 1A, B, C, D, and all those mean, and why 97 1G and H should have a meaning that only affects the current parliament and not other parliaments. They do not look at even the organization of parties and why parties have decided that persons who act inconsistent with in a manner that is inconsistent with the ideals of the party, who put themselves in rival positions to the party, lose their membership. Whatever. They do not even consider the NDC manifesto, neither did they consider NDC constitution, neither did they consider the MPP constitution or any other constitution. They do not even talk about the remit of the provision or whether there are similar provisions in other jurisdictions of similar nature. They do not even talk about that. So you don't see an attempt to do an interpretation by looking at the context, looking at other similar provisions in other constitutions, by looking at the whole provision itself and other parts of the constitution and all those. They do not look at that.
But this is the conclusion. It is in light of all the preceding discussions that this court determines that the plaintiff succeeds on the merits. In the result, this court grants the plaintiff relief 1A, B, and C, and makes the following further orders. Another declaring the interpretation placed on Article 97 1G and H as inconsistent with the meaning and import of Article 97 1G and H of the 1992 Constitution. Exactly, what are they trying to say? Are they saying that they remain in Parliament?
Well, what they are trying to say is that the Bogman's understanding, the Speaker's understanding of Article 97 1G and H is not consistent with their understanding. And since the Constitution gives them the power to interpret the Constitution in Article 131, that their interpretation is that the provision only affects members of Parliament of a particular Parliament, and that cannot be extended to affect a future Parliament. That's what they're saying. So the fact that the people had elected to file to contest on different political parties or acquired a different status in the next Parliament cannot operate to deprive them of their seats in this current Parliament. That's what they wanted to say.
Now, then, based on that, my colleague asked me a simple question. Under what conditions would Article 97 1G and H apply?
Well, what the Supreme Court is simply saying is that Article 97 1G and H will apply when a member of Parliament, sitting as a member of Parliament, decides to cross carpet or decides to move from where he sits to the other side of the party, like Professor Seniwayo did. That one will result in the loss of the member of Parliament seat, the declaration of a vacancy.
Well, when you read the Constitution, that's not the impression you get.
I'm not saying that I agree with their ruling. I've not said it, so have I?
So this, you are saying that essentially their decision means Article 97 1G and H can apply only to crossing carpets.
Or crossing carpet within a particular Parliament. So in the 8th Parliament, if you cross carpet in the 8th Parliament, you will lose your seat. But they don't consider a person who has taken steps, which steps are inconsistent with the party's constitution, or which steps are potentially inconsistent with Article 97 1G and H. They don't consider that to be cross-carpeting.
You are in politics. How applicable is this?
But you don't even need me to, as a politician, to tell you that the decision is contorted. In 2020, Michael Quay used the same provision. That petition of Makokwe was sent to Parliament by the MPP party. The MPP party had interpreted Article 97(1)(g) and H to mean that a person who takes steps inconsistent with his party's constitution loses the position with the party. And since a member of Parliament is a position of the party, that person will automatically lose that position as a member of Parliament. I think that everybody accepted the decision of the Speaker Makokwe. There was nobody who raised a finger, not even the majority leader then, nor the party. In fact, it was a party that invoked the jurisdiction of Makokwe to sack Amako from Parliament and declare his seat vacant. So one can say that there was unanimity, there was consensus that Article 97(1)(g) and H can operate to affect a person who intends to contest on a different party, having come to the Parliament on another party. There was unanimity until Parliament voted, or the people of Ghana voted to create a Parliament that has 137 seats, and one independent. Then Article 97(1)(g) and H, in the eyes of the MPP, assumed a different character.
Essentially meaning that your former colleague, Kwachi Akwa, who is member of Parliament for Memphis Central, is still a member of the caucus that is made up of NDC members.
That's what they are trying to say. That's what the Supreme Court is saying.
Now, does not present a difficulty.
It says also that Mamle Morrison is a member of the MPP caucus. It says that Kweku, that's a woman, is a member of the MPP caucus.
Yes.
When his party had said that no, if you do this, you automatically lose your membership of our party. So the Supreme Court is not determining the membership of political parties.
Because there are those who suggested that by this decision of the Supreme Court is essentially saying that Alan Kojo Chemantin
is a member of the MPP.
And everybody who has followed Alan remains members of the MPP.
All those who are following out with the MPP are members of the MPP. Because they are all expressing an intention to contest elections in 2024 Alan Chemantin wants to be president for 2025. And so he's a member of the MPP.
I see. That presents an absurdity.
Well, that's why I don't believe that the judgment will stand. The judgment cannot stand for two reasons. If you read the concurring judgment, the dissenting judgment of Loveless Johnson, she's so clear in her mind that the Supreme Court had no jurisdiction to interfere in the matter. Tanko goes further to say that even though he's going to disagree vehemently with the Supreme Court, she doesn't think that the Supreme Court has acted within its jurisdiction. So, and jurisdiction affects everything. If a court has no jurisdiction, there's no jurisdiction. It is not concerned. Jurisdiction is not concerned with the merits of the case.
Alhaji, thank you very much for speaking to us.
You're welcome.
ALHAJI INUSAH FUSEINI is former member of Parliament for Tamale Central, joining us on the line. So we're still trying to make meaning of what the Supreme Court has said. Yes. Now, does it help? Because they said now it's crossing carpets. So you move from one side of Parliament to the other. So let's